arbitration actually is a private dispute resolution mechanism, and it is effective for many reasons. One of which is that it's quite speedy, because both the arbitrator and the parties will normally work out a time schedule which is very, very congenial to them. Additionally, in arbitration, you will normally have subject matter experts acting as the arbitrators. So they will normally have a very good understanding of what the issues are about, and in that regard they are able to deal expeditiously with a particular issue. Other advantages are that in arbitration you have confidentiality and privacy, unlike what pertains in the normal courts where proceedings are public and open, anybody can go record and publish. In arbitration, it is very, very private and confidential between the parties and the arbitrators themselves. So for this and other reasons, it is very, very effective. Even in terms of cost, because we say time is money, because you are able to do that very expeditiously within a comparatively shorter period of time, you will be saving money in that regard. So arbitration is said to be cost effective. Arbitration is normally a win-lose situation like the court. One party must prevail and the other must lose. But what happens is that because of the way the process is structured, even when you are lose, you are happy because you understand why you are losing. And the parties will normally have closure. So arbitration is usually said to be final and binding. That is the award that is delivered at the end of the process. Not necessarily because of the subject expertise. In fact, knowledge in law is a big advantage. So what normally happens is that even those who are not lawyers but want to be arbitrators, they have to go through some legal education just to acquaint themselves with ways of assessing evidence, cross-examination, and other techniques that are very normal part of the arbitration process. In fact, it is said that arbitration is litigation in private. You see, which means that all the tools we use in litigation are also employed in arbitration, even though in a modified and more flexible manner. It is possible if the parties agree to it. In fact, in the ADR Act and the civil procedure that the court uses at the moment, the CI 47 in section 64 precisely, if parties have a matter which is in court, looking at the nature of the matter, the judge may suggest to the parties to try arbitration. And if the parties agree, they can take the matter to arbitration. Usually with very technical issues in court, because the court is normally of the view that if that matter should continue in court, it will take a very long time. But if they go to arbitration and they have an expert as the arbitrator or an expert as one of the panel members of the arbitration, then it helps expedite proceedings. So it is possible. Again, without even the court making the reference, the parties themselves can request arbitration. All right. And so all these are very possible. In that situation, it will not be possible for them to reach a written agreement. But orally, once they consent, it means they have agreed. You see, arbitration itself is like a contract. The parties have to negotiate the terms of engagement. They have to agree, first of all, to submit themselves to arbitration. And some of the proceedings are such that the parties have to agree on what should happen. For instance, when you come to the choice of arbitrator, for instance, especially in a situation where you have a sole arbitrator situation, the parties have to agree that it is person A that we both agree to conduct the proceedings in the arbitral process. Where you have a three arbitrator situation, what we call a panel of arbitrators. Each party would have to select one arbitrator, and then the two arbitrators that have been selected by the two parties will now select a third arbitrator who will function as the chair of the panel.